there, this is Kristen. I'm the Science and Engineering Librarian at Miami University. This is the first in a short series of videos on searching for and deciphering U.S. patents. This is the first one, and we'll be covering what a patent is and how it's different from other kinds of intellectual property. Okay, so on this screen we have three things: copyright, trademark, and patents. They're all kinds of intellectual property. But before we get into these, though, let me just say that these are legal matters, all three of them, and it can get very complicated, and there's usually lawyers involved. It's also a very different system outside the US. This video series is just talking about the United States in a very general way. I'm a librarian, not a lawyer. I can only give general information and not legal advice. Okay, copyright. Generally, copyright protects books, maps, literary works of fiction and nonfiction, music, plays, scripts, pictures, motion pictures, sound recordings, and other digital or analog methods of production, either published or unpublished. In the United States, people don't need to register their things for copyright. It's done automatically. If you're interested, there's more information on the screen, so go ahead and pause if you'd like to read through that. Next, we have trademarks. A trademark is an image, logo, name, or phrase used to indicate the source of goods and distinguish them from others. They serve a social function for consumers to know what or from who a product is from. So they are basically for brands. And again, there are more details on the screen if you would like to read those. Go ahead and pause the video while you do that. And we'll round out with patents, which are for inventions. Patents grant the holder exclusive rights to manufacture, use, sell, or build upon the technology, essentially a state-granted limited monopoly. There is no global patent system. However, there are treaties that ensure mutual respect for patents. Unlike copyright, patents must be registered. In the United States, patents expire after 20 years, typically, and then it's in the public domain for anybody to use. In the United States, there are three kinds of patents: utility, design, and plant. The definitions here on the screen are directly from the U.S. Patent and Trademark Office, which oversees the patents in the United States. So there are three criteria that need to be fulfilled in order to have a patent granted to you in the United States. The invention needs to be useful and have a purpose. It also needs to be novel or original, so no prior art or works basically that somebody else has already done. And it needs to be non-obvious to a person with ordinary skills in the area of the technology related to the invention. Okay, that's enough to cover in the first video in our patent series. So here's just a quick review. We talked about three different kinds of intellectual property: copyright, which is basically for literary and artistic works; trademarks, which is basically for brands; and patents, which are for inventions. Thanks for watching this video. I hope it was informative. There's another video in the series about searching for U.S. patents, and yet another for deciphering U.S. patents once you have found them. They are very different from research articles when it comes to searching and reading them, so stay tuned for tips, and as always, let us know if you have questions. Thanks again.